Your call has been forwarded to an automatic voice message system.
If you have court, and that's the message that you get when you call your attorney's office the day before, then this video is for you. Welcome back to the Divorce Broadcast channel. My name is Manny Segarra, coming to you from Miami, Florida. Today we're going to ask the question, is your attorney properly preparing you for court? Let me give you a couple examples of when they might not be preparing you the right way for court. If you have a court hearing and the first time that you hear from them that they start asking you questions about what you're going to testify about and what the evidence is going to be is when they're driving to the courthouse or parking outside the courthouse. No bueno, no bueno. That is not preparing the right way for a court hearing. Also, if the first time that you meet your attorney in person or on Zoom or actually introduce yourself to them is when they are walking into court as you're about to go in there and start a trial, not good. That's also not preparing the right way. So what should they be doing? What should attorneys be doing with you? I believe it to be all about the spirit of collaboration. Remember, you are the client you paid for, and you deserve to be informed and prepared whenever it is that you have to give testimony in court. So just like I like to compare it to a doctor's appointment. You would never get knee replacement surgery, some sort of surgery, a heart procedure, tonsils, whatever. You wouldn't just show up to the hospital and walk in and get that procedure done on you. That would be completely irresponsible. You would probably show up for an initial consultation, then you would go get the blood work done, you would show up for pre-op, you would get anesthesia, then you would have the operation or the surgery completed, and then you would have follow-up. That's how doctors do it. It is the same way when preparing for court hearings for attorneys, or at least it should be, especially when it's a divorce case involving issues relating to your children, to your family, to your assets, to your liabilities, to your entire new life moving forward. So this is very important stuff, and it needs to be prepared the right way. So what does it look like when an attorney properly prepares you for court? Well, it kind of depends on the hearings, because there are some hearings that don't necessarily need a lot of interaction or preparation because they may be legal issues only. So let's start out with the brief 5 or 10 minute motions calendars, case management conferences, status conferences. Usually a 5 or 10 minute motions calendar has to do with cases or an issue in the case that is simply purely a legal issue, either like a motion to dismiss, a motion for a more particular statement, a motion to compel certain discovery. Those are issues that don't require evidence or testimony. So the interaction or the contact that you may have with your attorney may be a little bit less in that situation. There are also what's called case management conferences or status conferences. Those are hearings that are very brief, 10, 15 minutes, in which a judge just wants to get an update on what's happening in your case. You may or may not have to show up. Some case management conferences and status conferences requires the clients to show up. Some of them do not. So it's important to know which one is which. So I like to lump together the legal motions hearings, a 5-10 minute motion calendar, the case management conferences, and the status conferences. And those brief hearings don't necessarily require you to sit down and meet with your attorney about it. It is sufficient for you to either give them a call or, even better, send them an email a couple days before asking what is the legal issue if it's a motions calendar, or what is the status update, what is it that we're going to do on these at this court hearing. Then the hearing occurs, and then you should send a follow-up email to your attorney saying what is it that happened in court today. You will get an update. Very simple, not complicated, doesn't require a lot of you going in person or meeting with your attorney, just requires kind of like an update. Next, mediation. Mediation is where most cases get settled. A lot of the jurisdictions require divorcing couples to attend mediation. In Florida, it is absolutely mandatory. At mediation, you and your attorney will go. You will meet with your spouse's attorney. Your spouse will be there, and a mediator will be there. Mediation is a great opportunity for you to try to resolve all the issues that are in your case. You will talk about the distribution of assets and liabilities. You will talk about alimony if alimony is an issue. You will talk about attorney's fees. And you will also talk about any children's issues like the time sharing schedule, the parenting plan, child support, and things of that nature. As you can see, mediations are very important because this could settle your case. So it is my opinion that a mediation conference is something that you should meet with your attorney beforehand. You don't need to meet with them in person. Because of the pandemic, a lot of preparation has been occurred over the Zoom platform. A lot of the mediations occur over Zoom. You can meet with your attorney over Zoom. You can have a phone call with them. But what is important about mediation is that you need to start figuring out what the different scenarios are for whatever the issues are in your case. Now, let's talk about evidentiary hearings. There are two different types of evidentiary hearings. The first type are specific motions, which we're going to talk about first. The second type of evidentiary hearing is the final hearing or the final trial on your case. Generally, the special set motions, which I'll talk about first, are motions that have to do with some issues that are pending in the case. So it is important that you meet with your attorney at least once before the hearing on that motion. The motion calendar hearings, it's important that your attorney explain to you what the role of the judge is, what the role of the opposing attorney is, what the procedure is in court, if there's going to be a court reporter there, to make sure that you show up in time. Your attorney should also be preparing you for your questioning. What is the evidence that needs to be elicited from you in order to prove whatever your motion is that particular day? There should be some form of bullet points, and perhaps they may ask you some deeper questions to find out what it is that the particular issue entails. And then they should also be preparing you to start thinking about what the opposing side may be cross-examining you about. These special hearing motions, these specially set motions, are motions that require a little bit more effort than the motions that we were talking about before. Specifically, special set motions are motions that require evidence and testimony. So it's imperative that you meet with your attorney at least once beforehand. A little tip for all of you, remember that in each jurisdiction, there are deadlines for exhibits and documents that you plan on using. So you definitely should think about finding out what the deadline is for the exhibits, the marking of exhibits, and sending them to the other side. And have a conversation with your attorney about the exhibits, so that you are prepared for these special set motions. Special set motions usually can run between 2 hours to 4 hours. Sometimes they can run the entire day, but they're very important in resolving parts of your case because your case isn't over, but these are urgent or emergent matters that have shown up before the final hearing that need to be addressed. Lastly, the final hearing, the last trial in which all of your issues are going to come to a head. This is something that you definitely need to meet with your attorney at least once. It is something that you should guide yourself by the orders of the final hearing. A lot of jurisdictions here in Miami, we have what's called a uniform trial order. That uniform trial order sets deadlines for discovery and exhibits and things of that nature. It is important that you look to see if there's any type of order regarding what you have to do in these cases ahead of time. If there's an exhibit order, then you should guide yourself by that trial order as to when you should be meeting with your attorney. Also, you should guide yourself by the length of the hearing. If the court sets a final hearing for 2 hours, there's not as much preparation than if the court sets a final hearing for like 3 or 4 days. So if you see that you have a trial that's set for 3 or 4 days, that should be an indicator to you that there are a lot of issues that need to be resolved. Then you need to realize that you need to meet ahead of time at least once, preferably before the exhibits are due, and then another time perhaps right before the trial, so that you can get your testimony on the same page with your attorney, so that you know what to expect, you know how you're going to present your case, you know the different arguments that are going to be made, and you will be anticipating how the other side is going to come at you to cross-examine you. So those are pretty much some examples of how it is that we need to make sure that our attorneys are preparing us correctly. Just kind of in sum and in recap, if you have a simple 5-minute, 10-minute motions calendar, status conference, or case management conference simply on legal issues, you don't require as much preparation or meeting time with your attorney. Usually a email or a phone call is sufficient. They will update you afterwards. For mediation, it is a little bit more intricate. You need to meet with your attorney ahead of time so that you are thoroughly prepared for all the issues in mediation, and you can hopefully settle either all of your case or part of your case. For special set motions calendars, these are issues that come up during the case. These are hearings that can last anywhere between 2 to 4 hours or the entire day. You should be meeting with your attorneys at least before the exhibits are due and getting your testimony on the same page at least a couple days before court. And finally, final hearings. Final hearings are the conclusion of your case and hence the most important. Guide yourself, again, by the length of the trial and the pretrial orders. What does the court require you to do? You should be meeting with your attorneys ahead of time, making sure that you meet the requirements of the exhibits, and you should definitely be meeting prior to the actual final hearing date so that you are prepared to present your testimony on the final hearing. And that's a wrap on how your attorney is preparing you and whether or not they are preparing you the right way for court. Thanks again. Remember that we have offices in Miami and Orlando. Please look us up at www.segarralawfirm.com. Se habla español. Please do us a favor, like the video, subscribe to our channel, and send this out to your friends that may be going to a final hearing and need a little bit of help. Wishing you the best of luck in court. Thank you.